Hi, everyone, and welcome to Overhaul of Davis-Bacon Act increases wage requirements and enforcement for federal construction contractors. Man, that's a mouthful. Thank you for joining us. We are here to talk about the Davis-Bacon Act and all of the changes that have occurred or are going to occur this October. And let's go ahead and do a few housekeeping items before we introduce ourselves. If you are getting HCRI credit for this, please stay tuned. You have to stay the whole darn time in order to get the code that you will need to get credit. So don't forget to do that. We'll be giving you that code at the end of the webinar today. If you have questions, please put them in the questions box or the chat box. We'll be monitoring that as we go and answer questions that are germane to where we're at as we go when possible. If for some reason we don't get to your question, we will follow up with you after the webinar. Sometimes we have time, sometimes we don't, but we do our best. Next slide. This is the lovely Sarah Nash. She is here with me today. She is my partner in the Labor and Employment Group. She is what I would consider my Davis-Bacon or our Davis-Bacon guru, and we are so glad that she made herself available today to join us. And then I am, next slide, Nichole Atallah. I have been with PilieroMazza a long time. I also am a partner in the Labor and Employment Practice Group and do a lot of prevailing wage work with Sarah, including the Davis-Bacon Act and the Service Contract Act. And so we have, we've seen this a time or two, and we are kind of in the trenches with you, anticipating what's going to happen with these new regulations. Next slide. So who is PilieroMazza? If you're already a client, thank you. We appreciate your business, and our goal as a law firm is to really deliver results for our clients by, delivering not only legal solutions, but business solutions that fit within that legal regime, whatever it might be. And in addition to labor and employment work, we do a lot of general government contracts work, transaction work, corporate work, litigation work. If you were a government contractor or want to get into government contracting, chances are, we can help you with your legal needs. Next slide. So what are we really talking about today? After we got over the tongue twister that was the title of our presentation today, we really want to give you a primer on the changes that are occurring to the Davis-Bacon Act and the related acts, because there are some tangential implications here in these regulations. So we're going to give you a high-level overview. Embedded in that is this reintroduction of what we call the three-step method. What do we mean there? It's really a change to how prevailing wages are determined by the Department of Labor. From a practical perspective, we're going to talk about why you should care about why these changes have been made. It's really a reintroduction because this used to be the way that the Department of Labor did it. So we're going to talk to you about what it is and why it's there and why you should care. We are going to discuss this idea of application of these regulations by operation of law. And that's a big change from our perspective, and we think that it is going to impact contractors significantly, particularly in investigations. There is an introduction of a conformance process. If you do any Service Contract Act work, you are familiar with conformances in the conformance process. So we're going to talk about what that means for you and for the Department of Labor. There are lots of changes to the debarment standards. The standard that the Department of Labor uses is being adjusted. There are also changes to definitions, which sounds really boring, but I think probably means the most in the context of the regulations. You take a change to a definition and you can really change the meaning and the impact on contractors and the government. And so we're going to talk about some key takeaways and notable changes that you should care about as we have gone through. I don't know, Sarah, how many pages of regulations was it? A lot.
Yeah, it's hundreds and hundreds. Let's leave it at that.
Yeah, so we're going to try to make this as easy as we can, given what we know now, and also talk to you a little bit about what we don't know now and what we're waiting for. Next slide. Okay, so just a general overview. Hopefully you know what the Davis-Bacon Act is, or construction labor standards. If you're looking at the federal acquisition regulation embedded in FAR Part 22 and construction labor standards, there is a component of that that is dedicated to the Davis-Bacon Act, and it's a federal prevailing wage statute. Governs construction, alteration, and repair of public buildings or public works. So it's basically, if I were to sum it up in 15 seconds, it establishes wage and fringe benefit minimums for classifications of workers that are working on certain types of construction, alteration, or repair of public buildings or public works. Funny enough, they've changed the expanse of those definitions in this rework. The Davis-Bacon related acts, DBRA, these are requirements that go into most federally assisted construction projects. So if it's a state project that's getting federal funds, that might be a project that's covered by what we call the related acts. Next slide. So Sarah, I'm going to kick it over to you to talk to us about one of the major pieces of this thing, which is changing the calculation of the prevailing wage and why folks on this webinar should care.
Right. It's every lawyer's dream, Nichole, to talk about percentages and averages, because as we all know, math is just our favorite topic, but I will give it a try. So one of the biggest changes that we're seeing is the way that the prevailing wage is calculated. And Nichole mentioned earlier that this is not new. This is actually the way that DOL used to calculate the prevailing wage back in the 1980s. But they changed it since, and up until now, it's been a two-step method. The two-step method was essentially looking at what wage is paid to 50% or more of workers in a specific locality. And then if there was no prevailing wage, that's what I think of when I think of 50%, then they would look to averages and essentially use a weighted average where you compare the different wage rates that are in the locality and do some quick math and figure out what the sort of new calculated number is. DOL has flipped the switch a little bit here and is no longer looking at those two steps. They've added a third step, which if there is no majority wage that's paid to employees in a locality, then they will look at whether there is at least a 30% minimum of workers who are paid that same wage. So they've essentially added a step in between the 50% and the weighted average that says, well, fine, if there's 30% or more, that's enough for us. We will consider that prevailing. It's interesting, it's one of those questions of how are you coming to that definition, right? 30% does not sound like it's prevailing to me. So I'm sure we will see some interesting litigation come out of this where people are challenging the interpretation that we're working with. But again, this is not the first time we've been here, so we'll see how DOL defends its posture. Interestingly, there is a severance clause that's been incorporated into this rule, sort of similar to some other rules that DOL has recently been putting out. So to the extent that there is a legal challenge, DOL is probably expecting it and has included severability provisions to try and carve out the difference between challenge clauses and clauses that can go into effect on October 23rd, which is when the final rule will become effective. The question, of course, is what does this do? Why does this impact contractors who are in the construction space? You just submit a higher bid, what's the big deal? Well, there are a few big deals. First of all, whenever you're looking at increasing, the DBA rates, there's necessarily going to be stress on the market that will likely increase commercial rates as well. the question becomes, why would a worker accept $15 an hour on a commercial project if they could go find a DBA project that is paying them $30 or $40 an hour? We suspect that this change will just elevate wages generally, which is going to lead to increased cost of construction across the board. The other curious piece here kind of ties in with another topic we're going to talk about later in the hour, which is the operation of law changes that this rule puts into place. And essentially, Nichole's going to talk about it a little bit later, but it becomes a little bit more complicated to figure out when the Davis-Bacon Act or the related acts apply to your contract and what wage determinations apply. So I don't know if anyone on the call has had the unfortunate experience of dealing with a DOL investigation in the context of DBA work, but in those circumstances, one of the tools that DOL uses is, finding back wages that are owed. Sometimes those back wages can be attributed to, a contracting officer's or an agency's failure to incorporate the correct wage determination into the contract. Sometimes those responsibilities fall to the contractors themselves. And where wages have been increased, the likelihood of higher back wages is always going to be present. And so it's important to understand that we are probably going to see significant increases, in assuming that everything rolls out as DOL plans in the coming months, years. So something to keep an eye out for. I do want to add that one of the arguments that DOL has used for this change is that they're sort of looking at the definition of prevailing and saying, well, yeah, we can't get 50% maybe, but averaging doesn't do it either. And so that's how they're defending this shift from the two-step rule to the three-step rule. I also want to mention that a big part of the reason that the 30% is going to increase rate is because unionized construction has a lot of organized ability to submit the wage statements that you submit when DOL is going out looking at surveys trying to figure out what the prevailing wage is. So the more that you have a union presence in your locality, understandably, the more likely it is that wage rates will be a little bit higher. And where you have given unions a 50% threshold, maybe there aren't 50% of the wages that are union rates. But it just makes it that much more likely when you lower that percentage to 30% that you're going to get those union rates on the book. Okay. So there's some other changes that are interesting to the wage determination rates, not just the rates, but the fringe benefits as well. One of those changes is that DOL has decided that it will use the Bureau of Labor Statistics data to automatically update non-CBA wage determination rates. And this is a new change. Generally, you have to get a new survey in order to increase those rates. I think the idea is that the process of going through that collecting survey data is a lot more intensive than it would be to just be able to automatically adjust rates based on the BLS data. So there are some caveats on that. DOL can't do this more often than every 3 years. And we suspect that these updated wage rates will face course challenges. But for the time being, just be aware that DOL does have this authority. That's generally in line with a lot of the terms in the final rule. DOL is trying to make their life a little bit easier, which you can understand, but at the same time trying to memorialize some of the practices that they've been putting in place otherwise. So we're seeing a lot of, if anyone were to look at some of the DOL materials out there, there's some FAQs, there's some comparison charts. DOL is trying to minimize saying that these are huge changes. They're saying this is really what we've been doing for the last few years. We've just, memorialized it in a final rule. That's how they're justifying a lot of this stuff. And you'll see that sort of theme running through a lot of the changes we're talking about. Another change to calculating the WD rates is going to be that DOL has a little bit more discretion to adopt state or local prevailing wage rates. I think Nichole mentioned earlier on, there's this idea of states having similar prevailing wage rules. So for example, in California, you have not just the federal Davis-Bacon Act, but you have a California equivalent. And what this change to the rule does is it acknowledges that there are already practices out there where states are collecting a lot of this information. And to the extent that they're using the same methodology that DOL is using, the rule just clarifies that DOL can use that information directly rather than needing to conduct their own surveys. So again, looking at that process, making it a little bit easier for DOL to find prevailing wage rates. Another kind of big change here is removing the distinction between metropolitan and rural counties when it comes to calculating a prevailing wage. Previously, rural wage determination rates could not consider data from metropolitan counties that are adjacent to them. Sometimes you don't necessarily have all of the survey data that you need to determine a prevailing wage rate, in which case the DOL regs clarify, and this isn't new, that you can look at adjacent counties. However, the prior rule provided an exception and said you can look at adjacent counties, but not, if they're metropolitan rates, because that's just, you're looking at apples and oranges. It'd be like comparing Washington, D.C. rates to, I don't know, Fairfax, Virginia. It's just, you got a different supply, you've got different demands, you've got a different cost of living. However, this new rule takes away that prohibition, and now if you're in a rural county, DOL could, assuming it doesn't have its own prevailing wage data for that county, just pop in the metropolitan rates. So that's another likely change that will lead to increased prevailing wage rates and fringe benefits in the near term. Again, we'll see how that rolls out, but just keep it in mind that things could be increasing fairly soon. And Nichole is going to now talk about this fun topic, effective by operation of law, and sort of all that means, for government contractors, especially because it's just kind of a doozy.
Yeah, so traditionally, I mean, pre these regulations, the rule was that if it's not in your contract, it doesn't apply with respect to wage determinations and FAR clauses. So if clients came to us and say, look, we bid on this thing, particularly in contracts that are like, already service contract act contracts, but they might have a component that's construction, or it's not obvious that it should be a construction contract, maybe because of where the work's performed, or is it a public building or a public work? I mean, it's not always as clear cut as you might think as to whether the Davis-Bacon Act should apply or what wage determination should apply. And so sometimes, you bid on a contract and you don't think that the Davis-Bacon Act is going to apply because the clauses aren't in there, or the wage determination isn't in there. But this rule kind of would achieve something that DOL has long wanted to achieve in both the Davis-Bacon, particularly the Davis-Bacon Act in this case, but I think they'd like to see this in the Service Contract Act as well, although I haven't seen that yet, just to be clear. But basically what they're saying now is that, look, the Davis-Bacon Act is going to apply regardless of whether the clauses were in that contract. And they try to make they try to give us assurances that if that happens, the contracting agency will pay for it. But there is, we don't have a FAR clause yet. Right now, we just have, our good old price adjustments clause for changes in wage determinations. Should they be changed and incorporated into your contract? But, we have some concerns about what this does from a price adjustment / equitable adjustment standpoint. For example, it puts this burden on contractors to determine if they think a different wage determination should apply. And so you go ahead and you apply that wage determination. The agency comes back and says, no, we disagree. Well, you've already paid these people the wages. And so it really creates this space for dispute with the agency and puts a lot of responsibility on the contractor to, one, determine the often legal questions as to whether the Davis-Bacon Act should apply to this particular endeavor or not. And two, things like what's a public building or a public work, which is still, it's somewhat being litigated fairly frequently. So it puts a lot of onus on the contractor. I think what it does for the agency is it gets wages to workers faster, right? So for the Department of Labor, their position is, well, in the past, I had to go out to the contracting officer. I had to get the agency to incorporate the WD in the contract clauses. And then I could get wages, new wage rates implemented to people. And I didn't have to deal with, trying to get other wage determinations, et cetera, et cetera. Now that's all on the contractor to do that. So I fully expect that there will be some bumps in the road as we figure out, one, as we get a FAR clause, which we don't have an updated FAR clause yet. So that's a to be determined. And how this is actually going to work in practice. So DOL can institute these enforcement actions, again, before the clauses are incorporated, even if there was an error in the procurement process. And then contractors are going to be liable for the back wages, even if they never get their price adjustments. So you could have to lay out a significant amount of money before you even get wage adjustments or any adjustment to your contract price. Things practically you can do in the interim is, kind of look at whether or not we think there are solicitation defects, which we always want to be doing anyway. If a solicitation's issued and we look at it and we think, this really should be Davis-Bacon work, and I'm not sure why it was solicited without Davis-Bacon, that's really a solicitation defect, and we should be addressing that with the agency, either hopefully amicably, or if we have to, through pre-award protest or pre-award action, because the risk is so much higher for you now. It used to be that, well, like if they included the wrong wage determination or they didn't include it at all, I guess if the DOL investigates, then they'll have to incorporate the right stuff, and it's going to be a pain for us, but it's really not that bad. At the end of the day, it's not our fault, right? We don't have that luxury now. And then if you're, say you have a project that goes longer, like a year or more, and there are updated wage determinations, because the default wage determination is the published wage determination. They're not project wage determination. So if those update, we want to make sure that we're watching out for that as we go along. And, I think there are some bona fide questions here about, how we do that during the pendency of a project. But I think the goal is communication with your CO. And then we're going to have to muddle through how this price adjustment stuff is going to work. And, maybe we'll see the FAR Council, include that. I hope they include that as a consideration in the, the reevaluation of the FAR clause, because it certainly is a big gap in how this whole system, this whole ecosystem was supposed to work. Next slide.
Yeah, I'll also just add that this is sort of adding to the confusion around some DBA bids. Already there's this added expectation that you're, doing your due diligence, reaching out to applicable prevailing, like contractors or unions, about what the prevailing practices are. And this is just another one of those steps that can lead to just a little bit more work on the front end, right? Because it's not necessarily all going to be, all the best practices aren't going to be written down in the rules or in the FAR. It's going to be up to contractors to use some resources to get the answers, unfortunately. But I will progress to the next slide.
Good point.
I will try to, there we go.
And then we're going to have these changes to the conformance process. So there are a number of positions and job classifications that aren't always, they don't get data back in these surveys for them. And so a lot of times you are bidding on work and you say, well, there's not a position for X, work on this contract, and where do we put them? Maybe there's some highway work, maybe there's some general labor work, but you're missing a classification. And so what the Department of Labor sees is, because they didn't have certain data on certain classifications, that classification of workers isn't showing up in your wage determinations. And so they will get repeat conformance requests to get a wage rate for these positions. And so their regulations, if the regulations go into effect as we anticipate, what they want to be able to do is say, look, if we keep getting these same requests for conformances for particular position over and over, we are going to include those conformed rates in a wage determination, even if we didn't have enough survey data to determine a prevailing wage. So they're essentially, again, providing a new avenue for them to just determine what they believe a prevailing wage rate is based on this conformance process. It can be frustrating when you don't have a position on a wage determination. This will allow them to more quickly get rates on wage determinations. On the other hand, I think there, again, as Sarah mentioned earlier, questions as to whether we can really say these rates are prevailing in a locality because the conformance process doesn't adhere necessarily to the same guidelines for determining prevailing wage rates as the survey data does. So it definitely, as Sarah mentioned earlier, is really a change to make their job easier. To some degree, I think some contractors might actually like this change, because they're going to get some of these rates on a wage determination. They're not going to have to go out and get another conformance every single time they do it, which is kind of nice, but it does, I think, raise some questions. But I do think this is one particular area where there might be a number of contractors that are a little bit relieved that maybe they don't have to turn a blind eye to what they're paying folks and know they're not in compliance, or submitting the conformance request, which is a little bit of a process in and of itself. So, and then it relieves the burden on the contract, on DOL, to process all these conformances for the same positions over and over and over again. Next slide.
So the next change relates to, it really impacts contractors who are working on those related acts. Under the DBA, the debarment process really remains the same, although it's a good reminder of what that is and what enforcement mechanisms are in place. You might be familiar that violation of the DBA generally, or violation by a subcontractor that you have, could end in debarment, suspension, and debarment. And what the final rule has done here is it has made consistent the related acts and the DBA when it comes to what the standard is for meeting that debarment threshold. Previously, the related acts required aggravated or willful violations. So as you can imagine, that's a pretty high standard. You had to really intentionally get this wrong. That standard has now, under this new rule, been replaced with the Davis-Bacon Act's standard of disregard of obligations. It just means it's a little bit harder to show that debarment is inappropriate for those related act construction contractors, because you no longer have this high threshold of aggravated or willful. Now you just have disregard of obligations is sufficient. There are some other changes to the related acts debarment process. Previously, there were opportunities for the 3-year debarment period to be minimized. That is no longer the case. Now it's 3-year minimum. It's mandatory. There's also no ability to apply for early removal from that list, whereas previously there was. So generally, I mean, on one hand, it makes things a lot more simple, right? Previously, we had all these conflicting rules, and you had to keep straight whether you're performing on a DBA contract or a DBRA. Now it's all consistent, but unfortunately, it's consistent in a more sort of difficult way. It just means that you have to be extra vigilant, especially with that operation of law requirement, that you are on point with your DBA and DBRA compliance mechanisms. And it doesn't just apply to your workforce, right? It also applies to your subcontractor's workforce. So these final rules really hammer home the fact that your subcontractor's mistakes can be imputed to the prime contractor. The expectation is that the prime contractor is ultimately responsible, not just for flowing down those obligations, but for making sure that the subcontractor is complying with them. It's just, you know, it's just a reminder you have to make sure you have good indemnification provisions in your subcontracts, and a reminder that you can't just expect your subcontractors to know the rule, right? You need to, in some cases, best practice is sit down with them, make sure that they have someone who's familiar with these requirements, make sure that they're submitting those certified payroll every week, and make sure that the way they've classified the work is appropriate, because the risk here, of course, other than back wages and other penalties, is that you could compromise the future ability to win contracts. So Nichole had mentioned some of the fun definitional changes that we're seeing in these rules. One of the big changes is, well, maybe this isn't the biggest, but one of the changes is to the definition of site of work. This is one of those definitions where DOL said, don't worry about it, it's the same as it's always been. We're just, you know, memorializing what we meant to do. But it is sort of interesting to see the trend in some of these definitions. So at least for the site of work, the definition has been expanded to include secondary construction sites. That's not really new, that's already been there, but where a significant portion of the work is constructed there and where that site is dedicated to the project for a specific period of time. That's sort of how they've been reading the regs already. One of the new changes is that one or more, they define what a significant portion is, and essentially it's one or more portions or modules. So in other words, an example might be a room, where there's a room that's constructed, that is considered the site of work, even if the overall building itself is not. And this is really just part of the process of DOL wanting to either expand or clarify and make clear that just because the entire work site isn't construction, what you might typically consider to be construction, that room or that module will be considered. And this is sort of in line with what we've been seeing generally at the DOL. They are hard-pressed to apply the DBA wherever they have an opportunity. We've seen it often in installation contracts where you have both DBA and SDA contractors or employees performing the work. DOL is taking a very aggressive stance, consistent with these changes to the final rule, that Davis-Bacon Act is going to apply in those types of circumstances. Another key change that's really worth highlighting is this change to the definition of prime contractor, especially in the context of withholding and debarment. So the definition of prime contractor has been expanded to include any controlling shareholders or members of the business handling the prime contract. And let's think about what that means, right? First of all, it's going to be really fun, right? Figuring out what the definition of controlling is. What do you have to be? Is it just someone who owns the majority of the business? Is it someone who has the ability to make decisions about, the operation of the company? We'll find out. I would assume that this would be one of those things ripe for litigation. But just keep in mind that if you're one of those shareholders or members, this definition now includes you. And when a contracting officer decides to withhold, this can impact you directly. So just something to keep in mind as one of the big changes that we're seeing in these rules.
Real quick.
Can you hear me?
Yeah, can I add something real quick? Yeah, so the other thing that struck me about the definition of prime contractor is that it applies to joint venturers. So the definition of prime contractor also includes each party to a joint venture, not just the joint venture itself. And as Sarah mentioned, shareholders, member of the business handling the prime contract. So it really significantly expands the scope of prime contract. So what it could mean is that you should be even more careful about who you decide to joint venture with, because if your joint venture partner decides or does not comply with the Davis-Bacon Act, they will be held responsible, you will be held responsible, the joint venture will be held responsible, and if there's a failure to pay wages, that means you may have to pay for the joint venturer's failure to pay, which your joint venture agreements generally don't. There might be some indemnity provision in there, but you want to be very careful about your agreements, especially if they go broke or something, right? And they can withhold on any of your joint venture partner and your contracts, regardless of the agency. So you enter into this business relationship for strategic business purposes, and your joint venture partner is not compliant with Davis-Bacon regulations, they can withhold on any of your contracts at any agency in order to satisfy those obligations, which is a much broader reach than we've seen before.
It is broader. Unfortunately, we've seen them trying to get creative with this in other contexts. We would anticipate that they will certainly pull that trigger if it's a possibility, and just see how far they get with it.
Yeah.
So another couple definitions worth focusing on, and then I promise we'll move on from the definitional portion of this program. Everybody loves a legal definition, I'm sure. One of the definition changes relates to, quote, construction, prosecution, completion, or repair. And this has been expanded to include both demolition and removal work where construction will be completed subsequently at the site of the removal or the demolition. Not entirely surprising, but think about it. Basically, anytime that you have demolition that precedes the DBA work, even if it's not maybe envisioned within the contract, DBA could apply. And this is one of those things where, again, operation of law change is going to make this really complicated. It's going to be, I think, that much more difficult to evaluate what this question of, what does it mean for the DBA work to be planned or contemplated? Who's going to have that information? My guess is that the CO or the agency is going to have that information. But if you have this operation of law requirement, it just gets a lot more complicated to be able to, predict what the agency is going to do and whether they have correctly included or omitted a wage determination. Another good opportunity to start asking questions at the solicitation point to make sure that you have a good understanding of what's going to be applied. Another part of the construction, prosecution, completion, or repair definition is that it includes, according to DOL, a clarified, not expanded explanation of covered transportation and when that is included within the DBA work. There's a great sort of definition where they go into detail about transportation. Generally, someone who is performing transportation in a de minimis way, or just using it to drop off or pick up supplies, is not going to be covered by the Davis-Bacon Act. Those truck drivers who are dropping off materials just for the sake of dropping those materials off are not going to be covered. However, this entire process has been defined. The idea of what it means to be covered transportation has been defined a little bit more concretely, unintended. And so we'll see how those truck drivers are expanded. One of the changes, at least, again, DOL doesn't paint this as a change so much as a clarification, but one of the issues is that instead of just looking at de minimis, DOL has now decided in the definitions that you can add up a bunch of de minimis time. Suppose, you know, there's someone who's on the site for 10 minutes, 15 minutes here, 10 minutes there, 20 minutes there. That de minimis time, I think it's actually 10 minutes, could be added together. And if that added together time is something that's not de minimis, DOL expects that it will be paid at the Davis-Bacon rate. So if you do employ those truckers or are involved in the, you know, distribution of materials, important to take a close look at those definitions to make sure that your practice is consistent with where this change in the rule is going. And then the last definition that's probably worth spending a little bit of time looking at is the definition of a building or work. Again, DOL maintains that this is not an expansion, it's a clarification, but at the very least, the definition is expanded to explicitly include improvements or installations related to modern day construction activities. So in other words, they're saying they're bringing it into the 21st century. You've got your solar panels, your wind turbines, broadband, car chargers. Those, without creating any doubt, DOL is saying that those are included within a building or works or included within the DBA definitions. I don't know if we've mentioned it during this call, but the Inflationary Reduction Act is one of the recent Biden administration changes that has incorporated certain tax benefits for contractors or, you know, companies that pay Davis-Bacon Act rates to their workforce in order to get these tax benefits if they're working on. It looks pretty clear that these new definitions sort of have the IRA in mind and are very cognizant of the idea that the IRA is also expanding maybe the reach of the DBA in other contexts. Although, fun fact, it's not DOL that's responsible for enforcing the IRA, it's the Department of Treasury. We'll see if they are, or how DOL, you know, whether they stay out or whether they really do lean into that whole process. The definition of building or work has also been expanded to include construction activity only affecting a portion of the building or work. Again, this is something that DOL has been trying to enforce already, but, you know, to make clear that just because it's just a room or just a piece of the building, that the new definition really emphasizes that it is considered a building or work, even if it's not the entire building or work.
All right, so there are some other changes. Look, I mean, I know it's hard to stay focused and there are a number of questions, and believe us, this is a substantial adjustment in a number of different places, but I'm gonna hit some of the highlights. There's record keeping obligations. And so most of you all, as a matter of practice, are likely keeping records. You're likely keeping your contract documents, your certified payrolls, basically all of those standard records. You might not be keeping telephone numbers and email addresses. So you need to keep employee contact information, contracts, subcontracts, related documents, and your certified payrolls for 3 years. So you want to, this was kind of a suggestion in many places before and what they wanted you to keep, but they're kind of now adding this 3-year period. And DOL has always taken the position that certified payrolls can be requested by the agents, by them at any time, and federal agencies have to produce them. And so, you're turning them in, but you should also keep record, because it's very possible that a contracting office comes out and asks you for them as well. There's also an anti-retaliation clause that basically protects folks that complain about their wages and fringe benefits under the Davis-Bacon Act. So it's yet another avenue, in addition to, some of the whistleblower protections, general OFCCP wage protections, NLRB, kind of protected concerted activity. This is another component that if somebody comes and complains to you about, or complains to the Department of Labor about their payment under the Davis-Bacon Act, you can't terminate them for that or take other retaliatory measures against them. Oftentimes, these happen to be workers that have challenges with the employer to begin with. So this can be a little sticky sometimes, and now we have an explicit anti-retaliation provision. Sarah mentioned before that they clarify prime contractor liability for the acts of subcontractors. And you are already seeing, because of changes at state level in particular with independent contractors and construction contracts, if you're a Maryland employer, you might have seen. So we're already seeing some of the bigger GCs include very stringent clauses in their contracts for, subcontractor compliance. Like, you have to make sure they are complying. So again, this kind of couples right along with that. There's some other stuff in there that you have to be aware of. There are some adjustments to, it's not even on the slide, some adjustments to the apprenticeship rules, which I thought were interesting. So if you're using apprentices on your job sites, you might want to go and check your program against the final rules and make sure that you're okay there. And that there is some guidance on administrative fees that can be credited towards the contractor's fringe benefit obligations. DOL has always had some level of consternation about fees being charged against the fringe benefits. For example, if you're paying your third-party administrator a fee to administer those benefits, and they are clarifying under what circumstances those fees can be credited against a fringe benefit. What they're really looking for is your normal operational, your normal operation, your normal practices. You can't charge that against. If you're outsourcing kind of a normal administrative task, that is likely not going to be able to be credited against your fringe benefit. But if it's the fee that's attached for the administration of the 401k plan or any other sort of benefit, that you can still take credit for. But I think they wanted to add some meat on those bones, because there has been some pretty intense discussions with the Department of Labor and industry groups and other contractors. There's been some litigation around what fees can be charged against the fringe benefit amount, because obviously that's money that's not going necessarily to the employer. There has been an annualization kind of requirement for contractors that do kind of private commercial work and federal work. Department of Labor has again says that, look, we're just codifying a position we've always taken. As you know, or can gather from a lawyer's perspective, it's fine for the department to take a position, but if it doesn't comport with the regulations, we're kind of gonna give it due weight when we're talking to our clients about, how to handle a particular situation. And so codifying things means something. And so it basically, this annualization of fringe benefits essentially lowers the amount of fringe benefit that an employer can count towards their Davis-Bacon contributions. And so it can be a little frustrating sometimes, but you have to annualize some fringe benefits if you have folks working on commercial and government work. There are some changes to enforcement and penalties that might be applied. I thought it was really interesting that they are now saying that interest is going to be applied to back wages and interest will be compounded daily. That's not something we've really seen in the past. So there's a lot packed in here, folks, just so you know, and we will do our best to provide updates as we go. And as we see, for example, the FAR clause come out, we will do our best to keep you informed so that you can make changes accordingly. Next slide.
Absolutely. We've got a number of questions. Do you want to tackle those now or after the key takeaways?
We thought we could, yeah, we can, because our next slide is kind of wrap up, right?
Yeah, in conclusion.
Yeah. Yes, we can certainly do that.
Okay, some of them, we've got a couple over, and we'll try to get to all, there's a number that have rolled in. We'll try to get to all of them. To the extent we don't, we'll try to follow up to make sure that folks, you know, aren't left hanging. One of the questions that's come up, Nichole, I think a couple times is where people can go to find the wage determination for these construction contracts. Just as a reminder, none of this has gone into effect yet. So as of now, you don't have to go out and find anything. But come October 23rd and come, basically, DOL has indicated they're not going to start enforcing this on contracts until the contract has been issued after October 23rd. So it shouldn't impact your current contracts, just future contracts. But Nichole, where should people go to find this notorious wage determination?
SAM.gov should have the basic wage determinations. They're not going to have every single wage determination, but they have most of them. The other cautionary tale that's like, I think in a gray area, Sarah, correct me if I'm wrong, but the DOL puts out periodic adjustments to the wage determination. And I think there's a question as to when you would be required to update them. I do not interpret what I've read so far as necessarily requiring you to check every month to see if there's been a change. This is really meant to address blanket non-incorporation and having the wrong wage determination at the outset of a project, or 30 days maybe before, I think it's 30 days before the project is set to begin. I'm not sure if you remember that, Sarah, and I can certainly check that for everyone. But I didn't see an obligation
right.
to check every month.
You're absolutely right.
Yeah.
The only exception, right, is where your project has been significantly expanded.
Yes.
Hopefully there will be some additional clarification about what that means, and it's kind of similar to how it works now. If, for example, the government contracts you for a specific project and then they decide, well, actually we want to add on all of this other bells and whistles, that could be considered a reason to incorporate a new wage determination at that point. And also where they, most wage determinations are for the duration of the project. In some instances, you might have an IDIQ that has option years that are extended. If you have an option year, that's also considered a place where you should go out and find a new wage determination.
Right. So there's also another question, how often, so that was, it kind of goes to the question of how often you're going to have to update the WDs. Again, I wouldn't do that every month. Just, when you're starting a project, probably a good idea to check if your project substantially changes, and just checking to make sure that when you get a solicitation that you're comfortable with the wage determination that's been incorporated, or if it's not there, that you're taking steps to change that. And, there are a couple comments about how challenging this will be for a small business, and the SBA commented on that as well. We understand that, and what we can do at this point is, as kind of an industry and advocates, keep you updated on how to practically implement some of this and make it as manageable as possible. But we certainly understand that regulation is difficult for small businesses that are just trying to keep their head above water to begin with. And then when you layer a new regulatory scheme on top of that, that can be very difficult. Go ahead, Sarah.
I was just going to say, we've got a lot of questions about, it's sort of the devil's at the details about, you know, is this a site of work? Is this considered construction work? Is this considered a federal building? I think that unfortunately, DOL has made these definitions intentionally broad. And as Nichole mentioned, I think at the beginning of the webinar, there's a lot of litigation already out there about what it means to be a public work, what it means to, you know, be construction work. And so unfortunately, you know, we don't have all the answers. You know, we're happy to look specifically at the circumstances. That can always help. But one of the nice things about the prior rule was you didn't have to worry about this stuff. That was sort of the contracting officers or the agency's responsibility to figure out whether it applied. Problem here is that now that onus has been passed to the contractors in many instances. Hopefully, you know, for those straightforward projects, it's not an issue. But for the ones that are on the edges, yeah, it's going to be some growing pains. We only have 4 minutes left in our hour, so I think we have all the questions. We will try to get back to you to make sure that we get to yours, but I think we might want to move on to the key takeaways. What do you think, Nichole?
Yeah, that's fine. There are a couple I think I can answer really fast, but I think there's a general concern. Yes, sureties are considered prime contractors, so they could get wrapped up into compliance issues if they are finishing performance on pursuant to a bond. So yes, that could apply to them, and yes, individuals can be debarred. Yes, that certainly is the case. There was a question about conformances and how that process would work. You'll essentially, and what timing would be there, you would essentially see that position show up on your wage determination. But if there's no position on your wage determination and you need a conformance, you got to go get a conformance. So that should not change process-wise for you, but you should, the idea is that you would see those positions start popping up on wage determinations. Let's move on to key takeaways. And I think, you know, for me, we have a list of key takeaways. The effective date is October 23rd. You know, we've kind of gone over these new contractor responsibilities and obligations. If I had one, you know, piece of lawyer advice that I would give you sitting on a screen from far away, it would be, this is an opportunity to start looking at some of your processes, right? We will see on October 23rd some adjustments, some obligations, some things we have to watch for. If you have questions, you can certainly call us. But things like your record keeping policy, your apprenticeship program, your teaming agreements and subcontracting agreements, all of those agreements and contractual relationships and policies, procedures, you need to brush those off and make sure they give you the protection you need in light of this additional responsibility and this additional risk as a contractor. Because for lawyers, it's about what tools we have when someone calls us with an issue, whether it's an investigation that we're helping them through, or you know, I'm getting notice that my sub didn't pay, or, you know, even vetting. What's your process for vetting teaming partners, subcontracts? That is, I think, for me, Sarah, the overall takeaway, things that you can do now to get ready for this.
Absolutely. And remember that ultimately, when it comes to looking at liability and when it comes to that question of debarment, you know, the question is going to be, did you disregard your obligations? And what's the best way to show that you have not been disregarding your obligations? Putting in place policies that are designed to get ahead of any potential limitations and make sure to the best of your abilities that you're complying with the requirements. And, you know, they're not crystal clear, so there's going to be a difference of opinion along the way.
Yeah. Well, it's 3 o'clock on the nose, I think, according to my clock, and we certainly, again, appreciate your attention. We have a number of questions we need to get back to folks. Again, if you, we have a podcast, we will put out updates. You know, we try to do 10-minute little increments every couple of weeks. And we will, as we get more information or kind of further develop our understanding and the application of these rules, we will try to keep you updated. And you can always reach out to us if you have any questions. So we will get back to the questions that were asked on the webinar as well, but we appreciate your time. And